In this section, we're going to look at accountant's liability and malpractice. For those of you who will be accountants someday, you can think of this section as how to avoid getting into trouble, how to avoid prison time, how to avoid fines. And basically, we're looking at the general principles of accountant's liability in 3 areas. What are the general principles of law in accountant's malpractice liability? What is the accountant's liability to third parties given privity issues? And what provisions of Sarbanes-Oxley apply to auditors? So what constitutes malpractice of an accountant? Accountant must perform with the standard of care exercised by accountants performing similar services within the same community. If he or she negligently fails to observe those standards, there is both a breach of contract and a tort of malpractice. An accountant can be liable in negligence if there was a failure to detect the fraud. And the standards for accountants are found in both federal and state statutes, along with GAAP, the Generally Accepted Accounting Principles, and GAAP, the Generally Accepted Accounting Standards. Although accountants are not liable for the content of financial statements, they are liable for turning a blind eye to suspicious issues and items. And those who have damaged by accountants' work have a choice of remedy. They can sue in breach of contract in a tort action, and there is a statute of limitations. It's not available to third parties. And in that case, we say that there must be privity of contract. And they can also sue under the tort theory of liability, which includes both those in privity and third parties. And under those theories, they can sue under negligence, gross negligence, and fraud. Because malpractice is both a breach of contract and an independent tort, the client who is harmed has the choice of recovering for breach of contract or for the particular tort that is involved. Generally, the client will bring a tort action because there are higher damages under tort law than those afforded for a breach of contract. The statute of limitations on torts versus contracts may also influence the theory for liability. The statute of limitations begins to run on the tort of malpractice from the date the harm was discovered. However, the contract statute of limitations runs from the date the contract is breached. This time differential may be very important because in some cases the client may not realize that there has been any harm until sometime after a breach of contract has occurred. And in the environment of accountants' malpractice liability, accountants play a critical role in a company's ability to obtain financing through loans or sale of securities. There are limitations of liability. Disclaimers of negligence must be clear and unambiguous and conspicuous. So we're talking about that in terms of the contract between the accountant and his or her client. So the disclaimers must be clear and unambiguously written, and they must be conspicuous in the contract. Limitations are valid when circumstances are such that it is not reasonable for the accountant to stand behind the computation. An example of this would be a company keeps 2 books. We refer to this as cooking the books. And they only give them, the company only provides the accountant with the second set of books, which are false, and the accountant prepares financial statements based on those second set of books. In that case, the limitations would be valid because the circumstances were such that it was not reasonable for the accountant to stand behind the computation because he was given a false set of books. And there are limitations on exculpatory clauses. Exculpatory clauses are found in contracts in which it's stating that regardless of the type of work that I do, the caliber of work that I do, or any mistakes that I've made, you cannot hold me liable. And it's very difficult to hold oneself harmless, especially in the accounting trade. Also applies to attorneys because you're held to a higher standard as you're professional and you're licensed. And it does not protect against knowingly making false statements. Accountant's liability to third parties beyond privity, and there are several sections here that we'll take a look at. First of all, we'll look at the status of the accountant. An accountant may be a full-time employee of a company, an independent contractor doing regular work for a client, or an independent outside auditor. What constitutes negligence is the same for all 3 types of accountants. The liability of the accountant to the third party, when recognized, is based on the reliance of the third party on the work of the accountant. Now we're going to look at conflicting theories of accountant's third-party liability in terms of negligence. And this is referring to all the differing views of courts as to when a third party may sue and what the plaintiff must show to bring such a suit. So first we'll look at the privity rule. It precludes a negligence malpractice suit by a third party, and this rule holds that only the party in privity with the accountant, that is, the accountant's client, may recover from the accountant. When the privity rule is applied, a bank lending money to the accountant's client cannot recover from the accountant for malpractice. Next, we'll look at the contact rule. In relaxing the privity requirement, New York, for example, now allows a third party to recover from a negligent accountant if there was some contact between the third party and the accountant. For example, an accountant may go to a bank to see what information the bank requires for the accountant's client to obtain a loan. In this case, there is a sufficient link or contact between the bank and the accountant to allow the bank to recover from the accountant if it sustains a loss because of the accountant's negligence. The New York contact rule requires that the accountant meet or communicate with the non-privity party to establish a relationship equivalent to privity. Next, we'll look at the known user rule. Under this rule for non-privity parties, the accountant is liable to third parties who experience a loss as a result of the accountant's negligence when the accountant knew that the third party would be using the accountant's work product. An example of this is a shareholder may recover from an accountant for negligently preparing and certifying an annual financial report that was prepared for distribution to shareholders. Next, we'll look at the foreseeable user rule. The accountant may foresee that a particular class of unknown parties will rely on her work. For example, when the accountant prepares a financial statement knowing that the client is going to use it to borrow money from some bank or finance company, the accountant foresees a class of lenders. And there are three more rules regarding accountant's third-party liability. The intended user rule, fear that the foreseeability rule does not sufficiently restrict the number of potential claimants, has led some courts to limit recovery to those non-privity users who were not merely foreseeable but also expected or intended to rely on the work of the accountant in a particular transaction or another similar transaction. In this view, the accountant must have furnished the information directly to the non-privity user or to the client, knowing that the client would transmit the information to the non-privity plaintiff. Then we're going to look at the flexible rule. Some courts have rejected the requirement of privity for malpractice against accountants, but have not adopted any of the rules discussed previously. These courts prefer to keep the question open and to decide each case as it arises. And lastly, we look at the unknown user rule. When the accountant has no knowledge of or reason to know of any third-party use of the accountant's work, the third party is not able to come within any exception to the requirements of privity. Consequently, a non-privity party cannot recover for the accountant's negligence when the accountant had no knowledge of any use that could affect the party. Outside of what we just looked at, we're going to look at non-liability parties, and in one case we're considering interlopers. There are some third parties to whom the accountant do not have liability, and no court imposes liability on the accountant to a total stranger who gets possession of the accountant's work and then sustains a loss because of false statement in the work. This applies regardless of whether the statement was negligent or intentional. An example would be, assume that a negligently prepared financial statement of a corporation is thrown in the trash and it is then retrieved by a security guard. If the guard thinks that the statement is a hot tip and invests in the stock of the corporation on the basis of the statement, the guard cannot recover from the accountant for negligence in preparing the statement. Accountants are not liable to interlopers, but courts continue to struggle with drawing the lines between interlopers and rightful third parties. And now we'll look at parties affected by the decision of accountant's client, and they're generally not liable. On the basis of information furnished by the accountant to a client, the client may make a decision that affects a third party. For example, a report by an independent auditor may indicate that an employee, a fiscal officer of the client, has not handled funds properly. Assume that the client relies on the accountant's report and then fires the employee. If the report of the accountant's was negligently made and the true facts would not have justified the action taken by the client in firing the employee, most courts would still hold that third parties harmed in this indirect way have no cause of action. And now let's look at the defenses to accountant's liability. So these are brought up in the event of a lawsuit, arbitration, that type of thing. So we look at both contributory negligence and comparative negligence. If you've taken the legal environment class, in legal environment of business class, then you're probably familiar with these terms. For contributory negligence, when an accountant has been negligent, The client's comparative negligence may reduce the accountant's liability. To establish client contributory negligence, the accountant must show that the client contributed to the accountant's failure or that the client ignored the accountant's instruction. For example, when a financial statement indicates that it is merely a working examination and is not certified by the accountant, the third party is negligent in relying on the statement and has been contributory negligent. In a contributory negligent state, the third party is barred from recovering against the accountant. Now, comparative negligence, some states apply, and these are more states use comparative negligence versus contributory negligence, and they apply the comparative negligence concept and permit proof of the client's negligence. Under the comparative negligence standards, the accountant and the client are assessed a percentage of blame for their respective levels of negligence in the use and preparation of the financial statements, and the client's recovery is reduced by its percentage of fault. So, for example, a jury comes back with damages of $100,000, but they find that the client was responsible for 30% of the resulting loss. So recovery from the accountant is reduced by 30%. So in this case, the accountant would only be responsible for $70,000. Okay, so far we've been talking about negligence. Now we're going to switch over and look at accountant's fraud malpractice. First, we need to ask ourselves what constitutes fraud, and it's a false statement made knowing its falsity or with reckless indifference as to whether it was true. Fraud liability to intended victims. For example, let's look at the case of Bernie Madoff Securities. The auditors signed off for years on financial statements that made the firm seem solvent when in fact the company had lost $50 billion. So in that case, the auditor would be responsible under fraud. Would be liable under fraud. Now, fraud liability to intended victims. Fraud by an accountant typically misleads a third party or a class of parties, a group whose identity is known to the accountant. Any such victim, whether an identified party or member of a class of potential victims, may recover from the accountant for loss caused by fraud. Privity, which relates to the liability for negligence, is not required when the basis of the malpractice suit is fraud. The public policy of preventing fraud overrides the concern of holding accountants liable to third parties. Next, we're going to look at Sarbanes-Oxley, referred to as SOX, and the auditor and accounting related provisions. Following the collapse of Enron and also WorldCom during 2001 and 2002, Congress quickly passed sweeping legislation designed to increase the liability for securities violations, for financial fraud, and obstruction of justice, and to impose new responsibility and accountability with regard to financial reporting by companies. These new provisions impose significant liability, and we will look at three different areas: auditor independence, audit committees, and records retention. One of the concerns reflected in SOX was that auditors were not exercising sufficient discretion and independence in conducting audits of their clients. The Act takes several steps to increase the auditor's independence as it conducts its audits of company financial records. The first area that we will look at is auditor independence. SOX created the Public Company Accounting Oversight Board, often referred to as Peekaboo. The board certifies firms. Annual registration is required by auditing firms. Board will set standards, discipline, and investigate, and requires that audit firms must disclose violations. Additionally, auditors must remain independent and not have any conflicts of interest. In many of the companies that experienced financial collapse prior to SOX, the company's auditors had conflicts that may have tainted their independent judgment on accounting issues or even on whether the companies were viable entities. For example, many of the audit firms received substantial fees from companies for management consulting services for which they were providing certified statements. An example of this is Arthur Andersen. If you've watched the Enron movie, the one that's assigned, then you will understand this clearly. Arthur Andersen received $21 million annually for its audit work with Enron and another $29 million for its consulting services. So basically, they were receiving almost $1 million a week from Enron for its services. The consulting contract created a conflict that interfered with the audit firm's ability to make honest decisions in its audit work. To help eliminate these conflicts of interest, SOX prohibits certain activities by audit firms for their audit clients. It includes things like bookkeeping, design and implementation of financial information systems, actuarial services, human resources, management function, things like that. And if what you're trying to do is outside of audit, but it's not on the statutory list, you must go to the peekaboo to get approved non-audit services in advance. And in addition to ensure that audit partners do not become entrenched, SOX requires audit firms to change audit partners at least once every 5 years. The rotation of the audit partner in charge of a company account brings a new perspective to the issues in the financial systems and reports and helps to eliminate the bias of close personal relationships that develop over long-standing working relationships. Now we'll look at audit committees. SOX also addressed these issues on the corporate side of the interaction between auditors and companies by requiring the establishment of an audit committee within the company's board. Under the statute, audit committees must be composed of board members who are independent, defined in the statute as directors who do not accept consulting or other fees from the company and who are not affiliated with the company, certain of its employees, or any of its subsidiaries. Members of audit committees must also be allowed to interact with auditors without management being present and also be permitted to hire independent advisors. At least one member of the audit committee must be a financial expert or someone who understands financial reporting and audit work. And lastly, we'll look at records retention. Accounting firm Arthur Andersen was convicted of one count of obstruction of justice for its destruction of the Enron records while the SEC investigations were pending. The conviction was later reversed because the court held that although there may have been sufficient evidence about individual Andersen employees' willful destruction of documents, the jury instructions were flawed in attributing that knowledge to the full Andersen firm automatically without proof of actual knowledge, which is an element in criminal cases. The statute used for prosecution in that case was not specific enough to tie the firm to individual employee conduct. Furthermore, the penalties, even with such a conviction, were minimal. As a result, SOX substantially increased both the scope and penalties for the obstruction of justice through accountants' and auditors' destruction of records. Under Sarbanes-Oxley, those who destroy, conceal, alter, or mutilate documents when either a civil or criminal investigation is pending are subject to up to 20 years imprisonment as well as fines. That concludes our section on auditor and accountant liability.